And I have to say, when I started my panel this morning, I bragged about how I thought it was the best assignment. But over the course of the day, I have to say the competition was more fierce than I expected. Maybe fitting. So our final group, led by Taylor Owings, is going to be sort of a recap on the day's events and some forward-looking thoughts.
Thanks so much, Dave, and thanks so much, everyone here, for your excellent questions and attention throughout the day. This has truly been an illuminating set of panels, and I'll harken back to, in fact, one of those questions from earlier, which was, what does all of this have to do with antitrust? And I'd like to say that that's what our panel is here for. So I'm Taylor Owings. I serve as a counsel in the front office of the Antitrust Division at the Department of Justice, and I've been delighted to be joined by several of my colleagues, basically this whole swath of the room over here today, from the Department of Justice. And I think one of the best things, if you ask any of my colleagues about doing what we do at the Antitrust Division, is that we really get to be students in our jobs. And usually that's being a student of industry, whatever investigation it is we're engaged in. We get to learn a lot about that industry and how the market works there. But today, I think this set of panels and the amount of rapt attention you've seen from my colleagues in hearing what the venture capitalist participants and observers have had to tell us about the way their investment markets work, and also what they're observing in the markets in which they invest, has been a really exciting and informative thing that we hope to take back to our jobs, our day jobs, being antitrust enforcers and bringing discipline to markets where they are broken as a result of failures in competition by monopolists engaging in anti-competitive conduct or in anti-competitive mergers. And so I'm going to attempt to elicit some learnings and some feedback and some observations from our excellent panelists here today on what we've heard, and some observations about how potential regulatory solutions might interact with some of the observations that we've heard today. And so we've amassed a group of people who each have a little bit of a different perspective, I think, from which to observe. We have an esteemed academic, an esteemed industry participant, and an esteemed industry observer. And so I will introduce them now. The first, the academic, on the far end, Eric Hovenkamp, is an assistant professor of law at the USC Gould School of Law, and he has a PhD in economics as well as a JD, both from Northwestern University. He has been a contributor to this body of research and thought on antitrust and competition policy, and especially how it interacts with innovation policy and incentives for innovation. He has published in many esteemed journals, including the Chicago Law Review, the Review of Industrial Organizations. I could go on. And he has been a lecturer in law at Harvard and Yale Law Schools. Our esteemed industry observer is Connie Loizos in the middle here. She is the Silicon Valley editor at TechCrunch. And so I'm hoping today that Connie can provide us a 10,000-foot level observation of trends going on throughout the industry, and can bring the sharp wit and perspective that she does to her strictly VC daily e-newsletter and event series. And then our esteemed industry participant right here to my left is Ted Ulyat. He is currently serving as an assistant professor of law at the Antonin Scalia Law School at George Mason University. But he has been a thought leader in both the public and private sectors over his time in both industry, serving as general counsel for Facebook from 2008 to 2013, as well as on the president's, in the administration under George W. Bush, including at the White House as deputy staff secretary, and as at the Justice Department as chief of staff to the Attorney General. He has also been general counsel at AOL Time Warner. He was on the board of AutoZone, and he was a partner in the venture capital firm Andreessen Horowitz. So this panel is really, I think, up to the task of reflecting on what we've heard today. But of course, as always, I'll remind everyone that we have an email address posted here on our slide where we encourage you to send questions or observations you'd like the panel to tackle. So the first thing I'm going to do is turn to the question that we've really heard echoed throughout the day, starting with the panel on kill zones this morning, but even Mike Moritz and Joe Grenfest talked about it really in the very first session of the day, which is the idea of whether there is an impenetrable kill zone around incumbent technology firms and whether that perceived dominance and inability to really enter that space is something that can be solved by having a narrow solution. Mike, I think, argued that you're never going to invest in a direct competitor to Google, but rather a VC firm could be interested in a narrow niche version of search or some other social network or some other company. And the question for my panelists is, do you essentially agree with the Mike Moritz model of thinking that there's no real problem that a good idea and a niche way of thinking can't solve? Or do you agree more with the Roger McNamee version of thinking that there are real opportunities that have to be built on the backs of platforms, and that the essential nature of some of what the platforms are doing is more along the lines of a common carrier, and that we should be worried about these areas around incumbent firms. So I'll start off with you, Ted.
Well, Taylor, thanks, and Macon, thanks for having us here. Appreciate you putting together today's event. On this, I guess I would be in the Moritz school, not the McNamee school. I think pretty firmly. I think there is still plenty of opportunity, plenty of VC investment, and the companies that are going to succeed are not dependent on big platforms. I think you even look at the big so-called dominant tech companies today, and each one of them comes from a different arena. I think you look at Google, Apple, Facebook, Amazon. Even if you want to throw Microsoft, each one of them, they all became extremely successful companies, to say the least, and developed in an area that was something new altogether, right? So Microsoft had the OS. Google comes in, doesn't think about the OS, just goes after search. Apple, goes through various cycles as a company and ends up, from 1980s Apple IIe's that we all remember to this, and many other things. Amazon comes at it a very different way. Facebook, what was social networking? People had no idea what this was. So I think there's venture money behind all of these companies, and there was an interest in investing and taking a shot, even though, especially with probably what Facebook, there was. You could look at the landscape and say, wow, there are these powerful competitors out there. How are we ever going to compete and build a multi-billion, multi-hundred billion dollar company? People still did that and still went for it, and were still able to build those companies. So I think you still have a healthy environment today. I would give a couple of, another example that we talked about the other day was map apps. Waze was, I think, a reasonable success from the perspective of its venture investors. But if you looked in 2000, Waze was bought for what, 1.3 billion by Google. Pretty nice outcome for the venture investors. If you had said at that time, or in 2010, whenever Waze was founded, if you said, should I do a map app? You might say, no way, because you got Google Maps out there, you got Apple that's embedded in the phone. Still, we're able to attract venture money to go after the map space and create a pretty good outcome for Waze. Anyway, so I think it's healthier than we might think.
I'd like to be in the Michael Moritz camp, but I am not. I just think that things have fundamentally changed. I think that we've never seen companies with network effects to this degree, companies of this size and stature and power. Waze is an interesting example, and of course Waze now belongs to Google. I think companies only have a finite period of time before they can either sort of coexist, get acquired by these companies, or go out of business, which I think is sort of a scary prospect for the future. And also, I think if Google hadn't been able to acquire Waze, the chances are it would have developed a competing technology. I think we're seeing more of that. I think we are seeing actually less acquisitions by these companies and more sort of just them developing the technologies that they see that are interesting. I don't think you're seeing as many sort of big acquisitions as you once did. So I'm actually sort of more in the Roger McNamee camp.
So I think I might fall somewhere in the middle. I think that it's the relevance of this kill zone idea to antitrust is not totally clear. We have to, I think, be a little more specific to get into sort of antitrust relevant territory, and we have to ask why are startups not entering this area? If it's not related to some kind of behavior, some kind of fishy agreements between firms, then it's not really in conventional antitrust territory. So for example, if it just seems too hard to sort of to compete with this dominant platform because this product is so much better, because his network effects are very strong, we can't really pin that on a conventional antitrust violation. So it might be a problem, but I'm not sure that it's an antitrust problem. That said, it's, I think, totally plausible to suggest that there are certain practices that some of these big platforms are engaging in that really are exclusionary, and that the reason that startups might not be popping up in a given area is because of those exclusionary practices. And in that case, certainly, I think it would be an important thing for antitrust to think about.
So we heard in the prior panel this concept of platform risk and VC investors thinking about really areas where they might be squeezed because they have to build on top of something like an IP provider, or excuse me, an ISP provider, an app store, or something like that. I'm gonna drill down a little bit more and say, are there specific types of platforms where you see there being a particular problem or a particular lack of venture funding to those types of platforms? Is there something that antitrust enforcers ought to be especially interested in?
I don't have in mind a particular platform or category of platforms. I would say the following. The incentive, for example, to exclude certain companies from your platform may only arise as a result of acquisitions that you would not call horizontal, meaning that they're not between competitors. So what might happen is a platform vertically integrates, it makes a vertical acquisition, and only then does it acquire this incentive to exclude certain companies, which would be competitors of the guy it just acquired. Okay, well, if to the extent that we agree that maybe there's a problem with platforms excluding a bunch of companies from their marketplace, we're probably going to have to start taking vertical mergers more seriously than the courts are right now. Right now, it's very, very difficult to bring a vertical merger case in the under American antitrust law. Some of the problems that have come up today could be sort of potentially solved prophylactically if we had a sort of more robust body of law surrounding vertical mergers.
I would sort of go back to what Patricia Nakachi was saying on the last panel, which is that I think the issue with a lot of these sort of platform companies, sort of their infrastructure, that, as Roger was referring to it, is that there is a single point of failure. So, if you want to reach a lot of consumers, you maybe have to go through the App Store, which is fairly neutral, I think, as this goes. Or you have to use, DoubleClick, Google's ad business for an ad-supported business. Or you have to, if you want to sell products, you have to go through Amazon to really reach scale. So I feel like that's sort of, it's great if you can, it's great if it's working for you. If it's working against you, you're sort of out of luck.
Eric, I'm going to turn back to you and ask you to share with the audience a little bit about your scholarship with Kevin Bryan and the antitrust limits on startup acquisitions. I particularly found a lot of the discussion that we were hearing earlier in the day about killer acquisitions and the potential for incumbents to be more voracious acquirers of new tech to relate to your findings or your propositions in that scholarship. And so if you could explain a little bit to the audience why it is you think that leading incumbent firms have the incentives to acquire new tech.
Yeah, so first I'll just start by saying that this notion of a killer acquisition, I think it's certainly an antitrust concern. I think it's one that probably comes up more outside of tech in areas like pharma, for example. Now, with respect to my work with Kevin, the idea, the sort of impetus for this paper was to try to make things as hard as possible for a potential antitrust enforcer. And in particular, so one thing that Mark Lemley mentioned is that, we put merger cases into two boxes and we're not really flexible at all. We've got vertical, plaintiffs pretty much always lose those. We've got horizontal. Well, it's important to, these two types of cases rely on different theories of harm. One is, much more sort of bread and butter antitrust, like you're eliminating a competitor, so the market becomes less competitive. The vertical case is a little more, there's more of a story there. It's an exclusionary theory where by acquiring this vertical interest, my incentives change such that, whereas this guy was maybe happy to sell to my rivals before, now that we're one entity, maybe I don't want him to sell to my rivals. And I think it's really hard in tech in particular to even answer the question of whether or not an acquisition is horizontal or vertical. And for that reason, I think ideally you would not, if you think that antitrust really needs to have a bigger presence in this area, it doesn't mean we're blocking lots of mergers, but that we should have some sort of coherent idea of how we want to handle these things. I think probably it's best if it does not hinge on this sort of bright line distinction between horizontal and vertical, or else that you have a sort of theory of harm that works even if it really is purely vertical, because many plaintiffs are just not going to be able to prove that a given acquisition is horizontal. So in this work with Kevin, we just sort of work under the assumption that, this is an economic model of an oligopoly market in which you've got one big dominant firm and a smaller rival, and startups pop up once in a while, and it's assumed that these are vertical acquisitions, meaning that but when one of the incumbents buys it, you're not eliminating a competitor. This way we're sort of making things as hard as possible for ourselves in terms of establishing whether a problem might come out of this. And so, the idea was just to see if you can sort of arrive at a coherent theory of harm under certain circumstances when you sort of have a totally laissez-faire, meaning no intervention, attitude towards startup acquisitions. And so, the result we ended up with is that once the dominant firm becomes sufficiently dominant, sufficiently close to being sort of a pure monopolist, that a number of problems arise, not just with respect to competition in the relevant product market, but also with respect to incentives for innovation by, prospective startups, innovators who haven't really yet come up with a working idea yet. One of those problems, sort of tangentially maybe, relates to this kill zone idea, which is that maybe innovators, because they are so intent on getting acquired by the big guy, that they sort of, this is really restricting what kinds of ideas they think of as worthwhile to work on. A good example might be, so you might suppose that the dominant firm and the smaller firm in the market have sort of equally good technologies, perhaps in some respect. And so sort of prima facie, we have no reason to say that innovators should work towards making their products compatible with the one rather than the other. Consumers might benefit a lot more, actually, if innovators would gear their ideas toward compatibility with the less dominant firm, with its technologies, to the extent that this would allow the less dominant firm to sort of even the playing field a little bit, make the market more competitive, and this would be good for consumers. That is almost never in the interest of the innovator, because there's just much more money to be made if you come up with an idea that appeals to the dominant firm. And so this is just one possible response to the claim that if you intervene in startup acquisitions, surely you're going to harm the incentive to innovate. Well, I think there are certain respects in which the opposite might be true, that you might arrive at worse incentives for innovation, at least in certain kinds of decision problems, when you don't do anything in this area.
Connie, it seemed to me that you might have been referencing something like this when you were saying earlier that you were noticing that perhaps innovation is drying up in some areas. Can you speak to maybe what part of the life cycle that Eric is talking about, we're seeing today in Silicon Valley?
Well, I guess my big concern as a reporter who covers Silicon Valley is I don't think it's a matter of companies sort of strategizing about getting acquired by the big guy. I think a huge problem is, again, we have like 5 companies that are the most powerful AI companies in the world and become more powerful every day. They have their hands in everything. And they are sucking up the talent in this world. There's like 200,000 people who are AI specialists. And before they can even really get going, they graduate from school, and Facebook is like standing on the university campus with like a bouquet and $1 million check. So it's a little bit hard for them to sort of get going when the prospects always of starting a company are very low. Your chances of success are sort of statistically very low. So I think that's a huge problem. I don't know how we solve that. I don't know if that's a DOJ thing, but I think that's sort of, we're talking at like a higher level, but I think we have to sort of get to the root of like letting people flourish for some period of time before they get pulled into these companies. I think that's a huge problem.
But on that, often, I think one of the great aspects of Silicon Valley that's helped create this great, create so much innovation out here is the free movement, precisely this, the free movement of labor, right? The non-enforceability of non-competes here, it's a classic element of Silicon Valley. I just think it's been so critical. So maybe that happens. Maybe you graduate from Carnegie and you get the offer right there, but then you come in and perhaps build some financial security for a couple of years at Google. But then, as we've all seen time and time again, the tendency is this company's become too big. I'm sick of the bureaucracy. I want to go create my own startup. And so people get in and get launched that way and come to the Valley to work in this relatively secure environment at the big company, and then roll out and do their own thing.
You're absolutely right. I mean, we saw that like with Chris Urmson, who was the sort of pioneering engineer at Waymo, who now
Brett
has
Taylor,
right, exactly. So that does happen. But oftentimes, too, I think those companies do get folded back into their sort of original employer. So, I mean,
sometimes.
Yeah.
Dustin Moskovitz, another counterexample, right? Comes out, does Facebook, and now Asana is what I think.
Potentially going public.
Potentially going public, I guess, right?
We heard from several commentators throughout the day that a real model for acquisitions is the acqui-hire, or even if it's not the acqui-hire, that the most important factor in thinking about VC investing is the people. And that one comment that really stuck with me was the idea that you can do all the diligence that you want about what the addressable market is and where the market might be heading and the solution that the technology provides to the market, but the market may change over the time. And so in reality, what you need to be thinking about is the flexibility of the people. This struck me as quite different from the way that we at the DOJ typically look at motivations for mergers. And so I'm curious to hear, I guess we'll start with Eric, your view on the ways, the tools that antitrust enforcers typically use to try to understand the motivations and the likely effects of a merger, and how those potentially are incongruous with the tech merger world.
So I think that the biggest difficulty has to do with sort of the horizon on which you foresee problems arising, and in particular sort of how long you think you'll have to wait before they show up. So in a traditional merger case, you have two firms that are already big. Let's suppose we're talking about a horizontal case. So these are competitors. Well, the question that we ask, that we're trying to answer in the course of antitrust litigation is this going to cause prices to go up right away, like right after litigation, just as a result of eliminating a competitor from the market? So, we're able to focus on this very short term potential problem, not having to speculate about things far into the future. And of course, we have exactly the opposite problem when we're talking about tech acquisitions. We are pretty sure we know what's going to happen immediately. It's almost always going to be nothing, because the startup is very small, right? And it's not yet a significant player in the market. On the other hand, we do have maybe significant concerns about how this is sort of affecting the trajectory of the market moving forward. And so, we're worried that maybe this acquired startup would have been a big deal and a separate big deal, an independent standing competitor, and now it's not. And of course, that's one problem, is that's just a hard question to answer. But another problem is just that the current state of merger law is just that it's not really, it's all set up around asking this very short-term question, and it's not particularly well suited to sort of extending itself in the way that I think you would have to try to do in order to really evaluate these startup acquisitions.
So Connie, are we missing things as antitrust enforcers from having this viewpoint that Eric summarizes? Or is your sort of, again, I'll call it a 10,000-foot perspective from which to observe? Are you seeing buy and kill strategies being executed that our tools are just not allowing us to see?
I really don't think so. I think he's right. I think there's just so much that happens, and it's so unpredictable. I mean, you can sort of say, what did Google know when it bought YouTube? Well, I think YouTube was actually, as Michael Moritz was referencing earlier, trying to escape some copyright laws or copyright lawsuits. Or what did Instagram, what did Facebook know about Instagram that the rest of us didn't see, and we should maybe stop that? But I think there it was sort of more Mark Zuckerberg worrying that Twitter was going to buy Instagram and buying it. And at the time, it also seemed like they were, in both cases, overpaying. But last year, I think YouTube pulled in like $15 billion, and Instagram pulled in $20 billion. So very smart bets in retrospect, but I don't think we can credit the companies with having the foresight to have known that. I think the problem, additionally, is although I think people out here are interested in regulation, and I think there's probably some relief that despite the power of these companies and their lobbyists and their corporate attorneys and sort of the divided Congress, I think everybody's very excited that the DOJ is kind of paying some attention. I do think there is this fear of unintended consequences, again, as Patricia was saying. I think it's just, you don't want to invest in a company not knowing, I guess what regulation is coming, and also how those regulations are going to impact things like 5 years down the road, because it's very opaque.
Ted, maybe you can respond to something that we heard Ben Thompson talk about a lot, which is that the Instagram acquisition stands as kind of this big scary gorilla in the room that everybody's referencing when thinking about, have we designed our tools correctly? What's your perspective on the role of sort of foresight versus hindsight in thinking about that?
Yeah, in the sense, as expressed on the previous panel, of how could we have let Facebook, Instagram happen, right? And I think that is massive hindsight bias. I think I did this while hearing that there. Full disclosure, I was at the company during the acquisition of Instagram. So, but I think you just have to go back and remember not only Instagram, which seemed like a very unlikely bet at that point, 18-month-old company, 13 employees. Why in the world are you paying this much? A billion contract price dropped to $700 million because Facebook stock was performing so badly at the time the deal closed. But so not only Instagram, but think about Facebook at the time. Facebook of 2012 was not Facebook of 2019, 2020. And back there, I just Googled, Facebook IPO disaster, and 1,000 results come up. So that was the time when this was happening. And I pulled one of them up, and these are a dime a dozen. You can find these. Sorry if this interferes with the Wi-Fi here. But I pulled up just some article from that time, and this is June of 2012. And this is a professor, I won't name him, but it's not Eric. But a Wharton professor said, commenting on the massive decline in Facebook stock price between even May and June, he says, quote, "The fact is that Facebook has not yet been able to find an ad model to generate revenues commensurate with its valuation," which at the time was what would that have been, probably a $50 billion valuation compared to today, 500. So there was massive skepticism toward Facebook in the market. You guys, you have no mobile strategy. This is why your stock is tanking. And so viewed in that, I think it's important to keep that in mind. So the time that the FTC was looking at the deal, and it was notifiable, it's way above the threshold. FTC looked at it. Chairman Leibowitz was there, and this is a deal that it wasn't slipped through the dark. It was out there. Everybody knew about it. There are plenty of skeptics. Facebook is a company that hasn't even figured out its own way to do things, and is buying this it hasn't even figured out its own strategy, and is buying this company with no revenue. Forget profits. So I think there is a lot of hindsight bias. So you look at the companies today. I don't know that there's anything that FTC would do differently in hindsight. If Instagram had gone on as what would be the basis to block the deal at that point? To Eric's point, is this a horizontal merger? Is it vertical? What is a photo app relative to a social networking app? What's the market? Isn't the market ad revenue or internet ad impressions? It seems to confound inquiry a little bit, and I don't know that there'd be anything that the FTC would do differently there.
Eric, your scholarship speaks a little bit about the pros and cons of using Section 7, sort of a prophylactic merger review model, versus Section 2, a sort of after the fact to consider transactions. Can you speak a little bit to that?
If you have evidence, it's basically always preferable, I think, to challenge it ex ante before it happens. But
and why is that? Sorry, can you just
elaborate? You don't want to have to unscramble the egg. You don't want to have to choose between, in particular, unscrambling an egg and implementing a behavioral remedy, which is like an order to, you're imposing certain obligations or constraining the defendant's behavior in certain ways. This is requiring people to constantly monitor them. I think Ted does some of this, and everybody agrees that these are cumbersome remedies, that they're not, they're inconvenient in certain administrative respects. So if you can make a structural remedy work, like divestiture, or if you, in particular, if you could just block, if you're sure that something is bad and you could just block it before it happens, you avoid having to choose between two options that you might not like very much.
Well, let me push back on that and pause you right there. There's a couple of I think, important points that you're putting together there. One is the concept of how sure do you need to be if you're sure if something's bad. So that's one question. And the other is the concept of having evidence, right? Is there a distinction in your mind between being reasonably sure and then having evidence? Or are those one and the same?
Well, I mean, you could have a gut feeling, but I mean, I think that my idea is that when would it be advantageous to go after the fact, to come in after the fact? Only if you're not reasonably confident that it's going to be anti-competitive before it happens, and maybe you get more information because you've had more time to see what's happening, and then you can come in later. So for the federal government, if it wants to come in after the fact, there's really not a statutory bar. If they want damages, there's a 4-year statute of limitations under an antitrust statute. If they're just seeking an injunction, there's only a sort of common law doctrine that courts don't actually usually apply to the federal government. So the federal government can come in after the fact, and if it really wanted to, it could unscramble the egg. But if you feel like you already know that the acquisition is going to be harmful when before it happens, it's hard for me to think of why you would not want to stop it then, rather than making matters harder for yourself by coming in later.
So can I ask, so let's assume that we do have to unscramble the egg because we don't have the evidence in advance. We can't know how these things are going to play out. But now we have some evidence that these, grown to sort of these, massive size companies that maybe need to be pared back a little bit. So what remedies, are we talking about any practical remedies? Is there anything that?
Why don't I turn that to Eric?
Sorry, I'm sorry, what was the question?
I'm just wondering, like, when you say, it's not, nobody really wants to have to unscramble the egg, but maybe you have to unscramble the egg, like, what does that mean from a law perspective?
There are a lot of costs associated with disentangling two companies that have integrated into each other at all different levels of the business. So for example, not long ago, an acquisition by Northwestern Hospitals was challenged after the fact. The court said it was just unreasonably difficult to try to disentangle them. Right? So in these situations, usually you'll try to look for some kind of behavioral injunction, and again, that has a lot of features that are inconvenient. And so it's not really ideal either, but in some cases it might be the lesser of two evils.
One observation that Doug Melamed made earlier today was thinking about the incentive problems it might create to look back at past mergers. He mentioned the idea of a company, if they knew they were vulnerable, or if a whole industry knew it was vulnerable to retreading past mergers, that they might try to scramble the eggs more, or that they might try not to grow the acquired business too big to sort of tip off the antitrust enforcers or interest the antitrust enforcers. Do you, Ted, have an opinion on whether those sort of reactions to government regulation or exuberance might be realistic? Or do you think that that companies here in Silicon Valley are largely just putting their nose to the grindstone and doing whatever works for the company?
Well, I mean, it's so counterfactual and interesting that it's, the companies today don't think about it that way. Today it's, again, first of all, there's the interesting break between deals that are notifiable and that are reviewed, right? Over what is it these days, 95 million or thereabouts, right? So deals above that, which are all reviewed and all carefully considered, and deals below that, which can go through without review, which are usually the acqui-hire ones. But whichever way you go, today certainly, once you make the acquisition, you are off and running because you really fear your other competitors so much that you say, this was an important acquisition for us. For whatever reason, we decided it was important, whether it's an acqui-hire. Brett Taylor was, when Facebook bought his company in 2009, former Google engineer, now at Salesforce, just a great entrepreneur in Silicon Valley. When he came in, Brett was such a superstar that the company, Facebook bought his company and then brought him in, and he immediately became CTO. So that's an example. You just get him to work immediately as CTO of Facebook, just getting to work. And if it's a company with more of a product, you want to integrate that as quickly as possible. So I don't, if there became a world in which you were judged 6-7 years down the road, and people say we're going to come in and break this up, maybe it would cause people to not want to integrate as much. I don't think so, though. I think you'll, the fear of your competitors beating you at your business, the fear at Facebook of Google coming in and with Google Plus, which was at that time Google's launch of a social network effort, that you're so focused on that you want all hands on deck to get this new acquisition, whether it's a few great individuals to become top execs of the company, or whether it's a product. You want to integrate that as quickly as possible, and you're not worried about this outside risk that if we're too successful at staving off the competition from our rivals, then maybe the regulators will come after us. You're not worried about that.
Connie, how would you view that?
I think it's hard to know. I mean, it seems like it would have a huge chilling effect on innovation, I think, if you thought that there was some chance that your deal would get unwound. I frankly feel very sorry for the people who run Harry's shaving company, who thought they had this great deal and now do not. Of course, that's much more recent. I don't know what the answer is, though. I don't know. Mark, I think, had mentioned, sort of making it easier for companies to go public. Sort of allowing more, trades on the secondary market, which, it is all sort of one kind of organism. There is already a lot of activity on the secondary market. Nick of Union Square Ventures mentioned one of their portfolio companies, Carta, where there's a very active, vibrant, they want to develop, I should say, a sort of a more vibrant sort of private secondary market. But I think, getting a little bit of feel, but my bigger concern is sort of, it all is part of sort of, I think, also income inequality in this country. So you've got these big companies, and then you have fewer of them going public, more of them staying private, but only accredited investors who are able to invest in these privately held companies. So I feel like maybe there is, sort of allowing more people to invest in private companies is sort of a piece of this, as complicated and confused as that sounds. Do you understand what I'm saying at all?
I think that would be an argument that venture funding is so plentiful now and venture investing is so successful, right? Which
I'm not worried about the VCs.
Right.
That's my
but if one of the themes here today is venture investments being
squashed.
Being squashed because you have these massive platforms.
Right. I mean, so just in the same way that they're not investing in social networks, maybe they would invest in fewer companies that could potentially be, divested from a platform company. They'll find other things to invest. There's always something else to invest in: robotics, biotech, food, agriculture. They'll find other things to fund.
So one proposal that we sometimes hear for evaluating whether acquisitions are anti-competitive is to try to detect when an incumbent is overpaying for an acquisition, which might suggest that it's paying to protect monopoly profits. Are there tools that investors use to evaluate the potential for companies that we as antitrust enforcers could potentially use in trying to answer this type of question? Ted, can you talk a little bit about models of valuation in light of this?
And it's nothing that's going to be a surprise to you all. But it's a challenge with startups. The big challenge with startups is a lot of them literally have no revenue, and even if they have revenue, they probably have no profit or very low profit. So that's a traditional measure that you would use to try to value a company. But then it's all it turns out to be a lot of speculation. If you have a so-called pre-revenue company, then you say, well, what's the you might look at then total addressable market, TAM, right, and say, well, what market are we thinking about? What are we going for? Sure, we've got no revenue now. We have not even figured out how we're going to make revenue on this. Ad revenue is one way, but ad subscription being the main two. But here's our theory as to how we're going to do it. We're not making any revenue yet, but somebody nonetheless sees great potential in the company and is willing to make a bet. So those are some of the tools that this is why it's an interesting problem that you've identified today of venture and antitrust. Companies, just by definition, venture firms are investing in companies that are where success is highly speculative. You're investing, you're putting out a bunch of bets on many companies, many of which are going to be total failures. And you hope that a few of them do pay off, and you don't know which ones are going to pay off. You come in, the early investors in Facebook were late to the game because MySpace was out there, right? And that you had companies with two different trajectories there. You take Slack, right, which had a report, had some great news this week. Slack started off as attracting venture funding as a gaming company, and then ends up being a productivity tool today in a publicly traded company and a quite successful one. The VCs that invested, Andreessen Horowitz was one. I was not there at the time; it was before my time. But Andreessen Horowitz, among others, invested in Slack when it was a gaming company, and the success turned out not to be in games, but in this absolutely different field of collaborative communication. It's just very. There are tools that you could use. There are tools that you probably do use, but whether it's a venture investor investing in these companies or whether it's an acquirer buying that company, often it's no revenue and just outright there's a big bet, some of which pay off, some of which don't pay off. That's whether the companies can be successful.
So Connie, what do you think? Is there a way to tell whether an acquiring incumbent is overpaying?
No, Ted's absolutely right. I mean, there's no math. It's like a crazy math. I mean, they're betting on, really, they say it, and it's true. I think VCs just develop an instinct about a person. And so in the case of Stuart Butterfield, who's the founder of Slack, he'd previously founded Flickr. So when he had this game company, Tiny Speck, maybe it wasn't so exciting, but they really liked Stuart, and I guess they were smart too because Stuart then figured out another company. But yeah, I mean, the history of VC is, full of bets that sounded totally crazy, and in retrospect, were super cheap. YouTube, Instagram being two great examples. There's, many other companies that sounded super crazy, and in fact were really terribly, mispriced. WeWork possibly looks like it was one of them. So it's really hard, and it's interesting to me. I sat down not that long ago with the head of global tech banking at Morgan Stanley, and I was asking how even like IPOs can get sort of mispriced so badly, where the bank comes up with a price, and then the public market investors are willing to pay such a different price, and there's just a lot of guesswork all along the way. So I don't think that there is a great tool. I mean, people see total addressable market in different ways, so it's really, there's not a science to it at all.
Eric, some of your work suggests that antitrust enforcers should be concerned if they see a first-place incumbent acquiring tech that they don't need or plan to use, but are just trying to keep the second-place competitor from acquiring. Is there any way to tell in your mind if that's what's going on ahead of time?
Well, no, there could be. It's just harder to conceive of it happening in a typical tech acquisition. I mean, but this does happen, even in practice sometimes. So not long ago, the FTC brought this case against a company called Mallinckrodt. It was a monopolist in the U.S. in a market for a drug that treated a certain kind of disorder among infants. There was a synthetic version of this drug that was only sold overseas. And Mallinckrodt outbid everyone else to get the American rights to that drug. Okay, now it has this original drug, and now it controls the synthetic version. From consumers' perspective, they're fungible. Okay, and so it seems pretty clear that the only purpose of this acquisition was to eliminate a competitor. Okay, it was totally redundant in terms of what the acquirer ended up with, the only difference, or the only apparent benefit to it was eliminating competition. This kind of thing is, I think, not typical of what you would find in an acquisition in tech. You have, all the products are much more complex, and it's pretty much always going to be the case that when you acquire a company, there's something in there that the acquiring company is going to use. And so these sort of extreme facts aren't going to arise. The point of, our only point in sort of mentioning that is if you do in fact have evidence that a company is buying something and not utilizing it very much, that is suspicious, and that contributes weight to a plaintiff's argument if he's trying to challenge it.
Did any of the discussion during the data panel strike you as relevant to this point? Is it possible that a source of unique or unique data that, we talked a little bit about the flywheel effect from data and how, as a result, there might be a natural monopoly in a certain type of data. Did it apply in your mind to any of these topics that you're considering?
One of the big things I took away from that data panel, which was really interesting, is that even, is that it would be really hard to try to say anything categorical about antitrust and data, because I think it's going to depend very much on the nature of the defendant's conduct and sort of the relevant data and the extent to which it might create sort of a bottleneck. In principle, you can imagine facts that would give rise to a problem, an antitrust problem, where perhaps one firm acquires a sort of essential source of data and is not allowing its competitors to get access to this data. That, I think, if you find facts like that, that's very much, familiar antitrust territory. But it's also not clear that we should think about that kind of case differently than we would, say, a vertical merger case or something like that. So I think, there's certainly the potential for antitrust disputes to come up and involve data in some important way. I'm not totally sure that it would be sort of shaking the foundations of antitrust. It might sort of just fall within sort of the familiar rubrics that we're used to working with.
Okay, great. I'm going to open it up to a few audience questions before we wrap up the panel, but we also received one online, so I'll start with that one while everyone thinks of their questions here. So is antitrust law enforcement even the proper tool to address the competitive concerns of the power of technology platforms and their network effects? Do antitrust remedies apply? And then I'll add a appendage here, which is, or if there were a magic wand available to you to increase competition in some policy-based way, what would that be? Go down the line.
I'm going to have to think about the wand question for a minute, but I do think that it's really important in this area to, if we deciding there's a problem is really only the first question. The second question is like, is this really an antitrust problem? Is antitrust the right body of law to deal with this? Antitrust is sort of cumbersome. I mean, antitrust litigation is big and expensive, and it takes a long time. And it's not clear that it's the best tool for some of the perceived problems that have come up today. So I definitely think that's important. I think, for example, there were lots of discussions about potential privacy concerns, and to me, I'm a little skeptical that antitrust is the right body of law to deal with those concerns.
I don't understand the law. I'm not a lawyer. I don't know anything about antitrust, but I think data portability is very important. To be honest, I think there's a very small number of people who asks these companies to delete their cookies, but I think that should be, a remedy that's available to them. I think the company should not make it hard to do, which we'd reported on recently that, California passed this consumer privacy law, but now in some cases I think companies are sort of making it very hard to find like the data portals where you say, get rid of my information, or they're making them sort of confusing, so you end up kind of going through a menu and potentially, you know, clicking on things that are against your own interests. That's an aside, but I don't know how we solve the problem, but I think we have to make this information freer. I think ultimately that's a big part of the solution.
Yeah, I'm probably with Eric on this, that big tech these days seems to be getting blamed by both sides of the aisle for all sorts of, and you know, all sides of every ocean in the world for all kinds of problems, you know, whether it's censorship or hate speech or destroying democracy or just being too big, you know, income inequality. Just, you know, big tech seems to be. I'm not, you know, no one's crying for big tech, and I'm not encouraging people to cry for big tech, but there are a number of big tech companies get in that mix of a lot of these hot button larger issues, and then antitrust comes in. I think some people say, well, they're just, you know, big tech is too big, so let's make it smaller. And how do we do that? Well, antitrust, and these are generally not antitrust practitioners who are saying this. So I do think antitrust is ill-fitting for a lot of those. That bill of complaint, you know, those various bills of complaint that are laid against tech. I think the problem you're focused on today is interesting and seems to me to lie at the heart of antitrust law, which is how do we promote American antitrust law? How do we promote consumer benefit? And what is the best way to get the best number of products out there? And specifically here, how do we make sure that there's enough venture funding for the next big ideas, and so that we'll continue to have robust innovation in these fields for the benefit of consumers. That's great, and I think that is a place that antitrust can think about this as you are today with the conference and say, is there a problem? If so, is there not enough innovation? Is that because of inadequate review of deals? Is that because deals that are below the HSR threshold end up being massively impactful? I think those are interesting questions. But I think the broader stuff about, hey, let's just break up big tech because it's big. Antitrust is not the right tool there.
Is there any question from the audience? We've got the mic coming to you.
I'm nervous when Doug has got the mic.
I just want to ask the panel what they think about something I've been, this half-baked notion I've had about kind of reframing the merger way of thinking in this context. So I start with a proposition that was discussed in some of the earlier panels, which is that from the perspective of a VC, most of their investments are not profitable. Then they have the occasional home run. So one way of thinking of that, this jargon isn't quite right, although it could be right if I spent more time to explain why it could be, but is that the median investment from a VC is negative, but the mean is very positive. So starting with that frame now, let's talk about merger law. Normally merger law is in effect focused on the median. It's saying, is this merger more likely to be anti-competitive than not? And if the plaintiff fails to prove that, the plaintiff loses. One could think of the acquisition of the nascent competitor, whether Facebook, Instagram is this story or not, I'll leave to others, but one could think of that as a little bit like the VC's portfolio, which is if you start at time, one, and you don't really know what's going to happen, but you ran a simulation of all the possible outcomes, you'd probably conclude that the median outcome showed no real harm to competition, but that there might be, for some of them, a black swan event, a 10% likelihood that the acquired firm would have turned into the next big thing. And it didn't because the owner didn't want to cannibalize his current big thing. So why not, if you felt maybe after the FTC's investigation that we could identify 3, 4, 5 factors that maybe suggested there was more risk than in other cases, not of a likely outcome, but of a black swan outcome that would cause the mean of the distribution of possible outcomes of this merger actually to be anti-competitive, even though the median would be very pro-competitive. Maybe you say in that case, we're going to use, in effect, the mean rather than the median as our lodestar. We're going to say if 2 of these factors exist in an individual case, the burden shifts to the defendant either to prove that the black swan event is extremely unlikely, or to prove that there really are compelling efficiencies that would justify allowing us to run the risk of, hypothetically, a 10% chance of killing the next big thing.
And Doug, when you're talking about the just announced FTC inquiry into below.
I imagine that might generate these
Right.
factors.
Yeah, so very early stage, sub $90 million acquisitions, and you can see some trends. I expect we'll see that in some case. I assume we'll see some economists bringing the Melamed theory to, it's in some opposition to a merger, just going back and tracing a number of small deals. But I think most of the deals, I'm trying to think if there's any that are the hot button mergers that got through that were not notifiable.
I'm not saying this model should apply only to the sub.
But that's where you'd find the clues as to what.
I'm saying
Right.
that might be one of the sources of
Yeah,
data
okay.
that can cause the legal community to say, or the economic community to say, we think we've identified a half a dozen factors.
Yeah.
While they don't give us a high probability of a black swan, they say this is a case more likely than the others, and they keep going that risk.
If there are common factors, I'd be surprised. I think these are the cases we think about with these big acquisitions by the major tech companies, or even in the case of Facebook, Instagram, a non-yet major company at that point. I would bet they're flukish, interesting, varied, hard to distinguish the false positives from the false negatives. I mean, my bet, it's very interesting though.
And I think that harkens back to what we heard in the panel just prior to ours, which is if you did identify some of these factors, does that mean that investment funding would dry up for startups that might be rich in these factors, and how does that interplay with what we're trying to encourage in the investment community and in competition through innovation more generally as well? Would be one of my reactions.
I'll shut up. You could imagine a world in which if that kind of acquisition were prohibited, you would have more venture money, because the venture firms would know that the large firms couldn't then use various kinds of anti-competitive tactics to coerce a sale to the large firm, and that the venture firms could then look at this as a pure play for what, from a competition point of view, you might call the black swan outcome. From their point of view, they would call the next big thing, and they might regard it actually as a more open field.
I think we have time for one more question, if we can grab the mic over there.
It's at the end of the conference, and one concept has not really come up much. I'm curious to get some opinions on that. So Joseph Schumpeter's concept of creative destruction is probably the best paradigm for creating competition and reducing market power. And technological innovation is often driven by patent protection, which enables new entrants to gain market power against the incumbents who will inevitably fight. Today's incumbents practice efficient infringement, and they copy, and the new entrants generally are less able to enforce their patents today than they were a decade ago, for example. Any thoughts regarding trying to improve this situation?
If the patent is valid, then you should think it's bad if the incumbents are infringing it. But I think reasonable minds can differ about whether very many of the patents, especially in tech, that are really important, are important because they represent really novel contributions, or if they're just valuable because they were able to claim more than the patentee was rightly entitled to. So I'll just leave it there.
And Connie, maybe do you have a perspective on the trends toward investment in patent-protected areas versus reputational or user-based technology?
I don't. I'm sort of removed from it. I feel like you know, the startups I talk to and even the bigger companies will tell you that they try not to focus on patents. I mean, I think that they maybe file them sort of defensively, but I don't think people are, I don't know, focused on patents. I don't have transparency into that, frankly. What do you think, Dan?
Yeah, I mean, I think if we're talking software patents in particular, I think Eric, I think, framed it out very well. Software patents not popular among your rank and file Silicon Valley software engineer. Right? There's just a sense that let's open source this stuff. Innovation's going to come from open sourcing. Much better innovation is going to come from open sourcing my ideas rather than walking down to the legal team and helping them file a patent application. That's software patents. I mean, hardware patents quite different. I think bio patents very different attitude among both investors and engineers there. But I think Connie, your sense of where engineers and founders are in the software space is in accord with mine.
All right, thank you very much, and please join me in thanking our wonderful panelists.